Welcome on behalf of the MGAA to this talk on General Data Protection Regulation. I'd like to introduce Jade Kowalski. Oh, sorry, I'm supposed to say that there are no fire alarms planned. So if we have a fire alarm, it's a real one. And please leave, and that's the only exit. I'd like to welcome Jade Kowalski of DAC who has a lot of experience in this area. Jade advises clients across a number of different sectors on a range of data protection issues, including complex data sharing arrangements, telematics, big data initiatives, and data security breach management. She has notable experience in undertaking privacy impact assessments in advance of the rollout of new technologies and managing data transfer projects across multiple jurisdictions. She has particular specialism in advising on data protection issues in the insurance industry, having completed 4 secondments in the insurance sector. Jade is currently working with a number of clients to develop and implement compliance programs in advance of the implementation of the new European General Data Protection Regulation. Jade holds the BSc professional qualification in data protection. That's the short version. Thank you very much, Jade.
Thank you. And thank you so much for being here and for sitting down early. It's nice to see so many people so eager to listen to a talk about the GDPR. What I plan to do today is try and cover areas at both ends of the spectrum. So first of all, to give you a general overview of what the GDPR means at quite a high level, for those of you who are coming to this afresh. And also to take some areas and provide you with a bit more detail for those of you who might have been to a number of presentations on the GDPR already. So the particular areas that I wanted to focus on is what the UK data protection landscape will look like, the requirement to appoint a data protection officer and how you go about assessing how that applies to your particular organisation, how you approach updating your fair processing notices, and how to carry out a data protection impact assessment, with the aim of you being able to walk away from today with some action points that you can start to implement within your own business. So if we start at a high level and look at what the GDPR is and where it's come from, we are still operating with a very outdated law that doesn't really work particularly well with the environment that we are in today. We're now possibly cynically going perhaps too far the other way, and we're going to be working with a law that actually also doesn't really work for the world that we're living in today, because it's aimed at Facebook and it's aimed at Google and it's aimed at those types of organisations, and it doesn't really fit very well with what the rest of us do. It's an attempt to harmonise European data protection law, given that we currently have a patchwork of national legislation in each member state. So the grand theory behind it was that we would have a regulation which would apply directly and equally in each member state, and life would be much easier. What we have ended up with is 50 or so areas where possibly those writing the legislation thought, well, this is a bit too difficult, so maybe we won't address this here. We'll leave this for each member state to make its own decision. And we'll come on to talk about what that means and how we go about addressing that. It will be applicable despite Brexit for a number of reasons, but we finally have some clarity in terms of our position around the UK Data Protection Bill, which will write the GDPR into our national legislation, which means that for the short to medium term, until someone decides to re-look at it, we will have the GDPR as it stands, with the layer of those 50 or so areas where the UK can choose to implement its own rules. What it does as a piece of legislation is place greater obligations on organisations when they process personal data, and we'll look at what some of those mean. And it gives individuals as data subjects more rights which are easier for them to enforce. And then the last point, the key point really, and the reason why suddenly as data protection law we're much popular than we used to be, is because it changes the risk profile of data protection. And again, we'll look at the risk profile currently and what the risk profile will be at under the GDPR and see where the differences are. So if I could carve it up generally, and there are many, many ways that you could choose to split the different requirements, but this is how I choose to do it. I will take you around the checkerboard generally and just provide some snippets of key changes and key risk areas. So the first is this new principle of accountability. And the way that I like to think of this is, under the existing regime, you have an obligation to comply with the law. Under the GDPR, you have an obligation to comply with the law, but you also have an obligation to have a piece of paper or a policy or a practice that's documented somewhere that illustrates how you comply with that legislation. So it's about demonstrating what you do, recording it, evidencing it, and making sure that you have an audit trail of the decisions that you make around personal data. Certain processing activities will require a data protection impact assessment. And one of the things that I'd really like for you to walk away from today is some ideas around how to conduct one of those. So I've got a whole section on that. But that's essentially a risk review. And you will be required to carry out that risk review and document that risk review going forward. There are also two new buzzwords. What law would be incomplete without buzzwords of privacy by design and privacy by default. And these are two concepts that you are required to apply to the data processing that you carry out. So if we think of them in their most basic terms, privacy by design is about designing good data protection into what you do. So that might be a new IT system, that might be a new marketing campaign, but it's about making sure that you're considering those issues up front and then designing your project in a way that will be the most data protection friendly. And then privacy by default is about making sure that you have the most privacy friendly approach as your default setting. So if you think of Facebook and its privacy settings, to comply with privacy by default, your profile should be private, and then it would be for the user to make it public if they choose to, rather than the other way around. Jumping across to enforcement, which is the area that's really made the headlines, we now have fines of up to 20 million euros or 4% of annual worldwide turnover. That is stacked against a current maximum fine of £500,000. So there's a significant change there, which is really where the risk profile change has come from. On that percentage calculation, there's a really interesting concept that's been borrowed from competition law of an undertaking. So I squirreled away and went and spoke to our competition colleagues to ask them how they calculate what an undertaking is and how you calculate that 4%. And I'm reliably told that it's a grey area, as these things usually are, but that in a group company structure, there is a presumption that a parent is responsible for the actions of its subsidiary, which can be rebutted, but that presumption is there. So when you are looking at calculating your risk, you need to bear in mind that it could be the risk of more than just your specific legal entity that is at risk when you're looking at calculating that sum. Something that's had less publicity, but I think is equally important, is this new right of compensation, which includes distress claims. So we currently are in a position where the Data Protection Act only allowed for compensation in the event of material damage, and then that's been changed over the course of the past few years by case law. But there will be an express right for individuals to claim compensation in the event of a breach from you under the GDPR. And that could be a breach of any provision. So it might be that you haven't fulfilled a subject access request correctly. It's not just in relation to security. And we've started to see, and it is in the security space that these things usually tend to start, but we have started to see, in the event of a data breach, letters from claimant solicitors with a schedule at the back of 4 or 5 people who are each claiming compensation for distress, somewhere in the realms of £2,000 to £5,000. And it doesn't seem to be standard practice at the moment, but you can start to see how that practice might start to grow, and we might start to see group action type arrangements in the event of a data breach. And if you have a breach where you are looking at 100,000 customers affected and they're each claiming £2,000, you can start to see how those costs start to rack up quite considerably. Something that might aid this is the ability for a not-for-profit body to be set up and to bring those actions on the individual's behalf, and for member states to create an ombudsman to deal with claims of that type. So we might see something akin to the DPFOS or something, which would start to look at compensation claims in that particular area. Data subject rights, we have existing rights which are maintained and are made slightly easier to enforce. So individuals already have this right to write to you and ask for a copy of the data that you hold about them. The information that they're entitled to around that is now greater, so they're entitled to know who it is you've shared it with, where you got it from, and information in that space. There's also the removal of a £10 fee. So currently, if somebody wants to make a subject access request, you can charge them £10, which doesn't sound like a great deal, but that extra step wheedles out the people who perhaps were only asking for it because they had an ancillary reason for something else, or they didn't really want it. You have to, generally these days, to get a cheque or a postal order, you have to really want whatever it is you're asking for. With that being removed, it's been predicted that there'll be a quite significant increase in these requests because you will now be able to simply send out an email and ask for a copy of all the data an organisation holds. And it may well be that if we start to see that publicised more in the general press, as people become more aware of their rights, we'll see an increase in those. And all these things take time and management resource and cost to fulfil. And so you can start to see, particularly if you are in the consumer space and you are a consumer-facing business, you may well see those increase. Data portability is an extension of that. It's a more narrow right in that the individual can only ask for information they have provided to you, but they can ask you to provide that information directly to a third party. So they might come to you and say, I took my insurance out from you this year, can you please transfer it to somebody else because next year I would like to use them instead. Again, we're not really sure how we're not really sure about the volume of these requests that we'll receive, but you can start to see that if in the popular press they start to publicise this right, again, it might be something that people start to use on a day-to-day basis. There's a right to erasure or the right to be forgotten, as it's been deemed generally. Actually, in our space, we're quite lucky that we're regulated and we will generally have a legal obligation to keep most data for a certain period of time. And that obligation would trump someone's request for erasure. So don't be worried that you're going to have to suddenly delete everything that you hold because somebody asks you to. As with all of these things, there are exceptions to each of these rights. And so you would be perfectly entitled to go back and say, actually, we have a legal obligation to hold this for X number of time. We will delete it after that. There's a right not to be subject to automated decisions. So that looks at things around profiling, but only where a decision is taken about that particular individual. So if you are looking at e-traded models, for example, there might be issues around that there. But generally for underwriting or claims validation where there's a human intervention, that would fall outside of this. And then there's a right to object to direct marketing, which is maintaining the position that we have today. Fair processing notices I'm going to come on to speak about, so I will jump over that. Consent under the GDPR now has a new standard, so it has to be much more specific and granular, and it has to be in relation to each specific purpose you process data for. Actually, in practice, there are probably fewer scenarios where you need consent than you might think. For what I call normal personal data, so names, addresses, contact details, anything of that type, you don't need consent of the individual to process that. And actually, if you don't need it, don't ask for it, because then you get into all sorts of muddles when the individual withdraws their consent. So over on this side, there are other things that you can rely on as what's called your legal ground for processing. I don't know why they call these things such technical terminology. So it might be that the processing that you're carrying out is necessary for the purposes of contract, or it might be that it's necessary for your legitimate business interests. So over this side, generally no need to ask for consent, so probably best not to. Over here, with special category data, or what we used to call sensitive personal data, where you're looking at health data or criminal convictions, there's a much shorter list of those legal grounds that you can rely on. And generally, apart from when you're in the litigation space, you can only rely on consent. So it's over here where the burden is going to come from meeting this new threshold of what valid consent is. GDPR has wider scope, so it will now capture data processors, so those organisations who generally provide services strictly on your instructions. The typical example is your IT service providers. That's actually a really good thing, because currently any mistake or breach by your data processor is your responsibility. And it would be the ICO investigating you, and they have no recourse against the data processor. That's entirely down to the contract that sits between the two parties. Under the GDPR, they have their own obligations, they have their own liabilities. So that makes the playing field much fairer and takes away some of your risk. There's also an expanded territorial scope for those organisations based outside of the EU but who are deliberately targeting individuals inside the EU or who are monitoring their behaviour. And that sprang out of lots of organisations saying, can I simply unwield myself from all of my data protection obligations by re-establishing somewhere else? So that will no longer be possible. Jumping down to security, the general approach to security is still that it needs to be appropriate to the data that you hold. So if you are handling particularly sensitive catastrophic injury liability claims, the security around that should be much tighter than if you're just processing names and addresses. We then have these two breach notification requirements. Currently, there is no legal obligation, in terms of the ICO at least, to notify data breach. Under the GDPR, there will be two breach notification requirements. The first will be to the ICO itself, and that's a window within 72 hours. And the second will be to the affected individuals, and that is without undue delay. And there are actually thresholds for each. So you will not need to notify every single data breach. There is a threshold, and the threshold test for each differs slightly. The threshold for notifying the ICO is lower than for the individual. So you might be notifying the regulator, but not the individuals in some cases. And again, that's quite important to bear in mind, because there's been lots of talk about a data breach notification being required in every circumstance. And you might be raising your head above the parapet unnecessarily if you go and start notifying every single breach. Data protection officers is something that I will talk about in a bit more detail, so I'll jump over that one. And then best of the rest are some ancillary bits and pieces around how the new European Data Protection Board will work as a kind of super regulator that's designed to ensure that there's consistency in application with all the different European regulators. So, if we look at the UK landscape in a bit more detail, you may well have seen on the BBC about 3 weeks ago there was lots of activity around the UK introducing its new data protection legislation. What that was the UK's statement of intent about how it's going to interpret those areas where it can derogate from the GDPR. So we are expecting a draft bill this month, although we're quickly running out of time, which will set out almost something that says the GDPR will be hereby written into UK law from this date, and then it will set out how the UK will deal with all of those areas in which it can make its own rules. The statement of intent didn't really tell us very much. There were a few useful snippets in there. So we're going to have a new criminal offence around reverse engineering anonymised or pseudonymised data to make that re-identifiable, so that will become a criminal offence. They also confirmed that criminal convictions data will be treated as special category data, because that was left separate in the GDPR itself. But nothing in there that was too groundbreaking or really gave us the clarity that we need. We are kind of in a limbo position where the clock is ticking and time is running out, and so people are having to make decisions about GDPR implementation now. But we don't really know the entire picture and what the final landscape will look like until we get that draft. And that will then be subject to negotiation. So we're probably looking at the end of the year before we have certainty around how it will look. Something else that I wanted to flag was the e-privacy regulation, which governs direct electronic marketing. And the two often get quite confused. From the GDPR's perspective, the only right around marketing is the right to object. So that's where you see your opt-out and your unsubscribes on emails and newsletters. Actually, consent for marketing is governed by something else entirely. And it's currently the Privacy and Electronic Communications regulations, and they are being replaced by the e-privacy regulation. That is still in draft form, and we're not expecting to have any clarity on that probably until the new year. But the timeline for implementing that is also the 25th of May next year, which leaves marketing concerns particularly in a slightly grey area. That's a whole other talk in itself, but I just wanted to flag that there's a distinction between the two. So let's talk a bit more practically now about how you can implement the GDPR internally and what it looks like for you. One of the key things is the requirement to appoint a data protection officer, which doesn't apply in every case. So you only need to appoint a data protection officer if your core activities consist of processing operations which require regular, systematic monitoring of data subjects on a large scale, or if your core activities include large-scale processing of those special categories of data. And that analysis relates to your primary processing. It doesn't relate, for example, to your employee data processing, which is kind of ancillary to your main purpose. Carrying out that analysis is actually quite tricky, especially in the insurance space. There are examples of some insurance businesses which are so obviously consumer-facing that actually it's almost a foregone conclusion that they are caught. There are others, particularly where your focus is more on commercial lines, where it's not so clear-cut. And it may be that you need to do quite a detailed analysis of the size of data subjects that you process data about, the size of your book, the percentage of that in relation to other lines of business that you offer. Because we do see real pockets and real hotspots of data in lines like public liability, for example, on claim. You'll often have quite a lot of data there. And so whilst you might not initially think that you need to worry about it, actually, if you have a very big public liability line, you might want to consider that and look at that in relation to everything else. There has been some guidance at a European level which references insurance in a number of different places. It talks about processing of customer data in the regular course of business as being large scale in an insurance company context. I would perhaps argue that slightly the other way, and I would argue that in a consumer-facing lines space, because actually it wouldn't necessarily be routine in other spaces. And in terms of that definition of what systematic means, it talks about assessing risk, underwriting and pricing of premium as being systematic processing. So the first thing here is to really consider what it is you do and carry out that analysis. Don't immediately point a data protection officer, and we'll come on to the reasons why that's not advisable. But document that analysis, because if you decide not to, and then you're later questioned, you've got something that you can go back to and show. And generally, I think the regulator would be far more sympathetic if you had carried out the analysis but got to the wrong conclusion than if you hadn't carried out the analysis at all. So then if we start to look at what the role of the DPIA is and what it is that they are required to do, the role generally can sit within a group, and actually for most in the insurance space it sits within the group, and it's a function that is a shared service in different spaces, even in circumstances where you might have an MGAA and a broker or an MGAA and an insurer. Generally, the DPIA role is a shared service across the group, and that's entirely fine. They can actually be a DPIA that's shared across different jurisdictions as well, as long as they are accessible and they can communicate with both the data subjects and the regulator. If you have a pan-European presence, that's slightly difficult because of language problems, but it might be that you still have a single DPO and they are supported by a team in different jurisdictions who can carry out those conversations in local language. They can either be employed or they can be fulfilled on the basis of a service contract. So you could have an external data protection officer who you use and who monitors, but from an outward-facing basis looking in. They have to have expert knowledge of data protection law, and the thing that's actually really quite important that I didn't put on the slide is they need to understand your business as well. And I think particularly in the MGA space, where you do have quite complex data flows sometimes, that's just as important. It's not necessarily useful to have lots of data protection knowledge, but in an academic space, what they really need to be able to do is advise you how the data protection obligations impact your particular business. They can carry out other duties, but they can't be in a position of conflict. And there's guidance around areas which would be a position of conflict. So head of IT, for example, or head of marketing are roles where generally you decide how data is used within the business, and therefore that would be in conflict with the role of the DPO, who's supposed to be slightly independent. A number of our clients are looking at retraining people internally to carry out this role, either as their sole role or as part of another job. And I've seen it sit in lots of different areas. Legal or compliance generally seems to be the most popular. But I've seen it sit in other areas, and it might be that rather than go out and recruit somebody entirely externally to just do this, who's going to be another headcount for you, it's going to be another resource that you hadn't necessarily budgeted for. Is there somebody internally who you could look at reskilling, providing with the right tools? They might already understand the business really well, and so they might already tick that box, and it's just the data protection knowledge that needs to be layered on top. Then we'll move to look at the position of the DPO in the organisation. And it's really important here to bear in mind that data protection obligations fall to you as an organisation, and the DPO is there to advise you. And you have responsibilities to do certain things to help them in their role. So they have no personal liability sitting as data protection officer. The liability would attach to the organisation as data controller. So things that you have to do is to make sure that the DPO is adequately resourced, both in terms of expertise, so if they're asking to be sent on training courses, or resource, if they're asking for another team member to help them with something that's particularly time-consuming, those all have to be considered. They can't be instructed on how to carry out their role, and equally, they can't be dismissed for performing their role. So it puts them in a slightly protected status space within the organisation, whereby just because you don't necessarily like the advice that they are giving to you as an organisation, they couldn't be penalised or dismissed for that. So there's a HR piece here that you need to take away and make sure that your HR teams are aware of about how this position is governed. They also have to report directly to the highest level of management. That doesn't necessarily mean that they need to sit on the board. It just means that they need to be providing updates directly which get considered by the highest level of management. Then if we look at the responsibilities of the DPO themselves, when you look at the detail, it's actually more of an advisory role. So you, as the business, take the decision as to what's done in relation to processing of personal data, and the DPO is there as a slightly independent person to advise you whether that's compliant or not and how you might do things slightly differently. But fundamentally, the decision remains with you as the organisation as to whether or not to do that. So they can inform and advise on compliance obligations. They will monitor compliance both with the law and with your internal policies. They will advise regarding data protection impact assessments, and they will cooperate with the ICO as regulator. And then really importantly, the thing that gets missed quite often is that they are allowed to take into account risk. And the risk that they will be looking at will be the risk to the data subjects, which might be slightly different from the risk that the business is looking at in terms of they might be looking at reputational risk or financial risk. But they are still allowed to take that into account. So when they're advising you, if something was in relation to consumer lines or monitoring of employees, it might be that their advice would be different if the same situation arose, but it was just in relation to quite vanilla data of names and addresses. So they are allowed to advise in that risk space. I mentioned earlier about how it's really important to carry out that analysis and document whether you need a DPO or not. If you don't need a DPO, but you would still like to have somebody who's looking after data protection, call them something else. Call them data protection manager or privacy lead or data protection champion or something else instead of DPO, because you can voluntarily appoint a DPO, and if you do, all of those protections around not being able to be dismissed and having to be correctly resourced apply. So just be really careful about inadvertently appointing somebody and binding yourself to these obligations when you don't necessarily need to. Privacy notices are the next thing that I wanted to talk about. These are the notices that sit on people's websites or in your policy documentation or in your proposal forms that generally no one apart from the data protection lawyers read. But they are really useful because they are the window dressing that you have. And they are the first thing that people see and generally look at if they're making a complaint. Or if the ICO is looking, I fully expect that that's probably the first thing that they would go to. Currently, all you need to tell people is who you are, what you do, and then this really vague category of anything else needed to be fair. The GDPR now gives you a quite long list of all the things that you need to include in your fair processing notice, which requires quite a lot of work for you to go through and collect and be able to understand and then be able to put into that document. Things like identity and contact details should be fairly easy. The purpose of processing and that legal basis of processing, that's the really, really difficult one. Because within each of your organisations, you will have, outside of the normal insurance space, you will have analytics that sit in the background. You might have customer propensity projects. You will have marketing. You might have a big data pool somewhere. You'll have employee processing. On claim, you'll have all different fraud analytics. You need to map out each one of those processes and then attach to it your legal ground. So we're back to the two lists over here, and you need to match for each purpose which legal ground you're relying on. That in itself is a mini project, but once you've got a grip on those things, having that information at your fingertips will feed into lots of other requirements. So it can be quite a painful task to go through, but once you've got that piece done, you'll then find that lots of the other requirements become much simpler. You need to list out the categories of data, sources of data, recipients or categories of recipients, details of international transfers, data retention periods. That's always really tricky. In the insurance sector, generally, there is an issue with data retention in that a lot of systems haven't historically deleted data or can't even delete data. Now we have to be quite upfront about how long we're keeping data for. And there is a balance between how far can I go in this notice before I start to embellish what's actual practice within the organisation. So that's sitting up and making people look at their retention practices in detail. Data subject rights, whether or not you are legally obliged to provide that information in order to access the service, automated decision making, and the right to lodge complaints. It's quite a big project to put all of that information together. That needs to be provided in each instance when you are collecting personal data, either whether it is from the individual directly, in which point you should be giving that notice at the point you collect the data, or if you obtain that data from a third party, you should be giving it either within a month of obtaining it, or when you're next speaking to your next touch point with the individual, or when you're sharing it with the third party. As with all these things, there's an exception to this, and that is where the individual already has the information. So if you have a routine data flow whereby you are receiving data from a third party who's not the individual, quite often what happens is that you will ask them to provide your privacy notice on your behalf. And that becomes part of the terms of the contract between the two of you. It might be the broker, for example. You might ask the broker to provide that notice on your behalf because they have the touch point with the end individual, and then you have met your obligation. So the approach to updating privacy notices is usually to, first of all, carry out that data mapping exercise to find out the data that you have and what it's used for. There can then be quite a geeky technical analysis behind the scenes of mapping those processing purposes to those legal grounds, so that you've got that information at your fingertips ready to include. Most people are starting from a template document, which they can then use in different scenarios so that all of your communications have the same look and feel. So it might be that you will have a different privacy notice for direct versus broker business, but actually lots of the information at the top and tail of it can be the same. Equally with your employee data processing, you could use the same template format. The Lloyd's Market Association has been doing some work around producing a template notice that isn't finalised yet, but shortly will be. So that's something that you can look to utilise. And that will set out the different sections that need to go in, and also include something that details how personal data moves up an insurance distribution chain, which is designed to cover off all of those different data touchpoints. And luckily, the ICO still endorses the layered approach, which means that we don't have to put that very big long list in all of our documentation. We can still have a smaller insert which has the key information, which then links through to a wider privacy notice which would sit traditionally on your website. That makes it easier for you to update. That keeps your documentation shorter than it would be if you had to include all of that information in one place. Finally, I will touch on data protection impact assessments, and then we should have 15 minutes or so for questions. And the reason why I've picked this as a particular topic to go into some detail on is because it's something that some of your businesses might not be familiar with yet, and it's a process that needs time to embed. So the sooner you can start with this one, the better, as then it will be embedded in processes as you go forward. So what is a data protection impact assessment? It's essentially a risk review of either a new project or a new system or a new process, but from the perspective of data protection compliance. There are certain things that it needs to set out, which I've included on the slide, but the idea of this is that it's a living document and not just a checklist. So it's carried out at the beginning of a new project, and then it's reassessed as you go through. So you would almost have project activity, risk, proposed mitigation actions, and then you would have another column that details how you are implementing those recommended actions to mitigate. Again, you don't always need to carry out a data protection impact assessment. There are certain scenarios which trigger one. So it's required when processing is likely to result in a high risk to the rights and freedoms of individuals. As with most of these things, it comes down to a certain amount of discretion as to what your interpretation of that is. And one of the things that you would be looking to do is to document why you are not carrying out a data protection impact assessment if you conclude that a new project is unlikely to result in a high risk. Again, just so you have that evidence log if you're ever questioned as to why you didn't carry one out. We know that it will be required in cases of systematic and extensive evaluation of personal aspects, including profiling, which lead to decision making. So an e-traded platform, that's a really good example of somewhere where you can say, yes, we would need to do a data protection impact assessment in advance. Processing of special category or criminal conviction data on a large scale, so implementation of a new fraud detection tool would fall squarely within that. Or systematic monitoring of a publicly accessible space, so CCTV would be your usual example of that. And the ICO is going to publish its own list of when it recommends that a DPIA should also be carried out. And how do you go about doing one? The first thing is to carry out that almost triage process to work out if you need one or not. If you do, then you move to stage 2. If you don't, then you record that, record the decision why you're not carrying one out, and then everyone moves on. Most of our clients are preparing template documents so that they're carrying these out in a uniform and standard way. And those documents can have really helpful hints in there about the things that you would consider in a DPIA. So a good example would be looking at your privacy notice. Does your privacy notice cover what it is that this new project or this new process is intended to do? And that gets marked as a yes or a no. If the answer is no, then the action might be to update the privacy notice. There's a big piece around business management here because it's the business who should really be owning this process, and then the DPO advises. Sometimes there's a gelling of the two, and it ends up being the DPO's responsibility. Actually, in practice, as a business driver, it's supposed to be the business who owns the data protection impact assessment. The DPO advises, and then if there is any residual risk, it's for the business to accept or not accept that risk. There's a requirement to consult where the residual risk remains high, and again, that's something for you to analyse and determine as a data controller organisation. But there is potentially two circumstances where you might consult either with the affected data subjects. So let's think of a new system which will monitor your employee emails. That's an example where it would be quite easy to consult with employees as to whether or not they thought that that's something which caused them a big concern. If you're looking at the customer space, actually it's much more difficult to think, how do we go about contacting these people and carrying out a consultation? And what do we do if they come back and say that they don't like it? How do you weave those considerations back in? And then there's this consultation with the ICO where your residual risk is high. We don't have any clarity around that process, how that process will work. And I'm not sure what the ICO would say if you went to them and said our residual risk remains high, or what they would do in that scenario. So I'd be seeking as far as possible to avoid going to them and asking for their views. And then the final thing is to keep a DPIA tracker, because as I said, it should be a living document and it shouldn't be something that is completed and then sits in a drawer and notes all of these really high-risk areas, which might be a smoking gun later down the line if there was ever cause to look at that particular system or project or process. So it should be something that's tracked. It should be something where you can see the evolution of the actions and where you have somebody taking responsibility for the risk and either accepting it and mitigating it to the best of their ability or not accepting it, and you would see the actions all the way through to closure. And the idea behind them, I'm personally a big fan of data protection impact assessments. And they have been best practice for a couple of years now, so some of you may already be fairly familiar with them. But they do really help to address issues head on, because there's nothing worse than something being looked at just as it's about to launch and then a big issue being flagged. And by that point it's too late, or there has been lots of time and money invested in that. And then it's really difficult to unwind. Nobody wants to be the person sitting there saying, data protection won't allow this. Because generally, if you're considering things up front, data protection obligations will allow it. They just might allow it in a slightly different way. So we've got plenty of time for questions, if anyone has any.
Hello. A lot of MGAs are fairly small businesses, but they do handle data. Do they have to employ the DPO, or can they actually outsource it to a specialist consultancy?
No, you can absolutely outsource it, and that's expressly provided for. So you could have somebody internally who acts as your DPO, or somebody internally who holds another role and also acts as your DPO. But yeah, you can absolutely use a third-party provider to offer that service.
Could you clarify one point for me, please? If we are processing data for customers on the basis of to fulfill a contract, but you mentioned our data was looked after as part of our IT management by an outsourced company, do we need to get consent from the customer for that?
No. So as long as it's just personal data and nothing that's on the sensitive personal data or special category data side.
Hi there. The DPIA kind of templates, is there anywhere where you can direct us where we could get a template, or certainly a starting point to start building our own?
Yep. So the ICO has a really good website, actually, and if you're looking for a resource, they publish guidance that's really useful, which isn't always the case of some regulators, and certainly isn't the case of other regulators across Europe. So they have a whole section on guidance. Their DPIA guidance is drafted under the current regime. It hasn't yet been updated for the GDPR, but it has a template in the back that's quite useful. And the way that I do it is to almost walk through each of the different principles and then walk through each of the different data subject rights and have considerations for each of those, almost as headings down the side, to make sure that you're not forgetting to check your privacy notice or you're not forgetting to check your contractual obligations. But the ICO template is a good starting point, and it just needs a little bit of tweaking for GDPR compliance.
Sorry, a little bit of clarity on supply chains. The degree to which we may be responsible for the actions of other people in the supply chain. How likely is it that we'll be liable, and to what degree do we make checks of their arrangements?
That's a really good question. And in the insurance space, it's a quite complicated question. It largely depends on who it is you're contracting with. So if you are contracting with a third party who is your data processor, we're in a better place now because they have their own legal obligations around security and notifying you of a breach. But there are a huge list of things that you need to include in your contract with your data processors. One of those things is to look at how the liability is addressed. If you are contracting with another data controller, your liability would each fall to you as individual entities, as sole data controllers, and it would be up to you if you chose to implement a liability provision there. In a joint data controller relationship, so where you are jointly deciding the purpose and means of processing, which in the distribution space, under delegated authorities you're likely to be, you have joint and several liability, and that's where you really need a very clear liability clause, because an individual can come against either of you, and it's up to you to decide liability at the back.
In terms of the derogation powers, in a sense we don't really know until we've got detailed guidance, but do you think sort of common sense might break out in sort of realm of employer-provided benefits? So the employer is providing data to the company without the explicit consent of the individual, but it's for the benefit of the individual. Do you think that explicit consent clause will be subject to derogation?
That's a really good question. And actually, that's a really good introduction for me to tell you about a little bit about the work that the industry bodies have been doing specifically around that point. So we have this great list of legal grounds over here for personal data, and then we have this much shorter list of legal grounds over here for special category data, generally the most relevant of which is consent. In most instances in the insurance distribution chain, the particular market participant will not have a touch point with the customer to ask for that consent, or not even the customer, a claimant, a third-party claimant, or an expert or a witness. So at its most extreme, if you think of the reinsurer at this end of the chain, how on earth do they ask for consent from the individual right at the very beginning? And what would that individual think if they suddenly had a request from a reinsurer for consent? They would probably be quite alarmed. So the LMA, together with the ABI and BIBA and BIPAR, I'm told, I'm not sure if it's true, but I'm reliably told, that it's the first time all of the industry bodies have ever signed the same submission, have prepared a submission to the Department of Culture, Media and Sport. For some reason, they have been charged with implementing the GDPR. This is what we're dealing with. Requesting that there is a new legal ground that sits in this list, which allows processing of special category data where it is necessary for the purposes of underwriting or administering an insurance contract, which would mean that we wouldn't need consent. We as a firm have been heavily involved in that, and the submission went in back in March, I think. There has since been calls for further information around that, which reassures me that somebody has at least looked at it, which is always nice. We haven't had any clarity as to whether or not that will go through. I am checking my inbox regularly to see when we will get an update in relation to that. I suspect we won't get anything in advance of everybody else when the bill is published. And it would, you know, to us all in this room, it would make a great deal of sense to have that from the consumer's perspective, not only from our own. So I'm hopeful that somebody will agree with us. There are also other legal grounds that sit under secondary legislation under the Data Protection Act, which do allow processing of special category data in circumstances of fraud detection and prevention. We were quite confidently told by DCMS that they would mirror the current position. So I expect that they will be transposed across, and we will at least have some leeway in specific areas like fraud prevention.
I suppose just a bit of clarity, I think you touched on it. So this is between, I think the link between GDPR and cyber. Mm-hmm. So my understanding was if there's a breach in future that needs to be disclosed, which may have a benefit in terms of cyber, so it might heighten the profile of the number of cyber attacks, etc. So what's the threshold for that?
So the threshold is slightly different in terms of notification to the ICO versus the individual. One is positive, one is negative. So the notification requirement to the ICO is in all circumstances except where the breach is unlikely to result in a risk to individuals. So that's a kind of negative test there. The obligation to notify the individuals only occurs where there is a high risk to their rights and freedoms. And actually there are exceptions to the requirement to notify the individual. So if the data was encrypted and unintelligible and you can remotely wipe a laptop that's been lost, for example, you wouldn't need to notify the individual in that circumstance. But you're absolutely right. I think we will see the take-up of cyber cover increase purely because there's no mandatory obligation at all at the moment. And so to move to these two notification requirements is going to be quite a change. It's really key, I think, to have a terms of reference or some kind of breach register internally which records how you're making those decisions, because there is a liability that attaches for failure to notify a breach when you should have done. And again, to my mind, the regulator would be far more sympathetic if you didn't notify and you could produce your reason as to why you didn't notify, than if you didn't notify and it might appear that you had just simply chosen to sweep it under the carpet.
Where do you see legitimate interest sitting as one of the legal basis for processing personal data in the insurance sector?
That's a really good question. So legitimate interests only sits on this side, so it's only applicable in relation to processing of personal data. That's the first thing to note. And then it can actually be utilised quite widely. So the full legal basis of processing is where it is in your legitimate business interests and doesn't cause undue prejudice to the individual. So it's really important, I always shorten it, but it's really important to follow that through and to carry out that balancing exercise versus what's your legitimate interests, which might be outweighed by the individual's rights and freedoms. But you can use it for all sorts of things. In the space where you might have a policy with multiple insureds, and so you don't have a named driver, for example, if you don't actually hold a contract with that individual, so you can't rely on the necessary for a contract because they're just a named driver, in that scenario, that's a really good example where you could rely on legitimate interests. The way that I generally tend to think of it is that if there is no element of discrimination or there is no element where you can quite clearly see that there is a risk to individuals' rights, and if you have told people about it in your privacy notice, that's quite key, then you can be relying on that as your legal ground.
Hi, I think it's great that we've got sort of all the industry associations sort of combining on this one. What would it sort of feed back into the EU legislation and to the other countries? Thinking about sort of things like the CAT modelling things, so we've got AAR, RMS, they've got various data, and it's not just going to be the London market that needs that data, but you've also got others and Bermuda and wherever else, and US, that's a difficult one. Yeah.
That's a really good question. I am reliably told that there are conversations that happen at a European level. I'm unfortunately not privy to them, and that's actually a really good flag as a challenge because it is quite easy to think of our UK landscape in isolation, and if you do only offer policies locally, then that's fine, but for most there will be some European element. In Germany, they already have specific guidance around how the insurance sector can process personal data. In others, I don't think it's particularly thought of as an issue at all. And so we are in this slight predicament where it would be absolutely fantastic if we had this UK derogation for processing of special category data, but if you have a pan-European business, that then actually causes practical difficulties about what you do in other jurisdictions. There has been talk, I think, of a European insurance code of conduct around this. But the general feeling that I get is that from a pure coordination perspective, it's so logistically challenging that we've never got there to date. Maybe the GDPR will be the driver that encourages people to start to sit down and look at it again, but to date we don't have anything that's a pan-European guidance specifically for the industry.
Right. Well, thank you very much. I'd like to thank Jade for a very informative talk. I'm sure there will be more questions. Are you going to stay around for a cup of coffee afterwards if anybody's got any questions they'd like to ask personally? So if you'd like to join me in thanking Jade and DAC Beachcroft.